afternoon, everyone, and welcome to the Harris County Law Library's 19th Amendment Centennial Symposium. I'm Mariann Sears, Director of the Law Library, and it's my privilege to welcome you today, the very day 100 years ago that the 19th Amendment was ratified. The text of the 19th Amendment states in part that, quote, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex," end quote. By its ratification, women had secured the right to vote in the United States. So it's an honor to host this event, not only to celebrate this historic constitutional achievement towards equality, but also to share with you the stories of the brave women who fought for the right to vote, their struggles while protesting and pressing their representatives for progress, even as the 1918 pandemic raged on, are our struggles even today. And their successes have helped countless women participate in our democracy over the last century. I'd like to take this opportunity to thank all of our community partners who have helped make this program possible. The Law Library is part of the office of Vince Ryan, Harris County Attorney, and it is the Harris County Attorney's Office that has sponsored continuing legal education credit for today's program. Information about reporting CLE credit will be provided at the end of the program. We'd also like to thank our planning and community outreach partners. Our partners in the local legal community are the Women of Law organization and the Houston Bar Association, including the Law Week Committee, the Gender Fairness Committee, and the County Law Library Committee. Additionally, we'd like to thank our community partner, the League of Women Voters of Houston. And in honor of our partnership with the League, we'll offer voter registration information to all of you by email after the symposium. Finally, we'd like to thank everyone who submitted a question for our panelists as part of the registration process. If you'd like to submit a question during the program, please use the questions segment of your GoToWebinar control panel. We'll do our best to answer all the questions at the end of the program. And now it's my privilege to welcome our distinguished speakers. Our first speaker is Marie Jamison. Ms. Jamison is a partner at Wright, Close and Barger and a former staff attorney for the 14th Court of Appeals. She graduated magna cum laude from Thurgood Marshall School of Law, where she received several accolades for moot court participation and academic achievements. She also served as executive editor of the Thurgood Marshall Law Review. She is a member of the executive committee for the Garland R. Walker American Inn of Court and sits on the board of trustees for the Texas Center for Legal Ethics. Ms. Jamison has conducted extensive research into the history of the 19th Amendment, and we are grateful for her willingness to share her expertise with us today. Our second speaker is Professor Renee Konecki Jefferson. Professor Konecki Jefferson is the Joanne and Larry Doherty Chair in Legal Ethics and the Director of Law Center Outcomes and Assessments at the University of Houston Law Center. She earned her JD from the University of Chicago Law School and entered private practice prior to joining the faculty at the U of H Law Center. As a professor, she has earned international recognition and numerous accolades for her legal work in ethics and innovation in the delivery of legal services. She has authored 3 casebooks and more than 20 scholarly articles that are regularly cited by both legal scholars and other scholars. Today, we welcome her as the author of her most recent critically acclaimed book entitled shortlisted Women in the Shadows of the Supreme Court to discuss her expertise and research into inclusion of women on the nation's highest court. And our final speaker this afternoon is Justice Frances Borleo. Justice Borleo serves on the 14th Court of Appeals in Houston. She received her law degree from the University of Houston Law Center. Before she was elected to the bench in 2018, Justice Borleo practiced with the Texas Innocence Network and represented indigent clients facing the death penalty. Her expertise earned her an adjunct faculty position at the U of H Law Center, where she oversaw the death penalty clinic. In 2011, she joined the nascent Harris County Public Defender's Office and helped build the office's appellate division. In 2017, she started her own practice and represented clients in a variety of civil and appellate matters. Her expertise regularly garners invitations to present at CLE programs and conferences for the local legal community. And today we're thrilled to welcome her to share her experiences and to discuss the importance of the inclusion of women in law and government. Please join me now in welcoming this extremely distinguished panel. Ms. Jamison, the floor is yours.
Thank you, Mariann. And good afternoon to all of our attendees. I'd like to start by expressing my appreciation to the Harris County Law Library for organizing this symposium and having me and my fellow panel members. As Mariann mentioned, we are commemorating women's suffrage and the centennial anniversary of the 19th Amendment. I'm going to spend the first part of this program briefly discussing the history of women's suffrage in our country. Please keep in mind, however, that the suffrage movement was long, lasted over 70 years, and I will not be able to cover each and every event, suffragist, and turning point. But what I hope to give you today is a good overview of the movement and how the 19th Amendment has affected women's lives and our role in this country since it was passed. The 19th Amendment was certified on August the 26th, but today is ratification day. 100 years ago, the 19th Amendment was ratified by the states. To me, a century seems remote in time, but think about this for a moment. There are lawyers practicing in our courts today whose grandmothers could not vote. And even after the amendment was passed, poor women, women of color, still did not have the right to exercise that right, and they had to continue the fight. Going back a couple of millennia, scholars have looked at written records of various civilizations. And we know that life was harsh for women unless they had a loving father or husband. The quote unquote ideal role of a woman was one who was subservient and devoted to her domestic duties. In many societies, women were not even considered persons. But there were some exceptions. Cleopatra, the last pharaoh of Egypt, was the wealthiest person in the Mediterranean. Her kingdom was both the cultural center and breadbasket of the entire region. The Roman people and their leaders were envious of Egypt's wealth. They were horrified that a woman was the ruler and appalled that ordinary women had rights under the law. In the old kingdom of Egypt, women had the right to own real property, personal property. They could engage in commerce and enter into contracts. They also had the right to divorce and remarry. These civil liberties lasted until Octavian, Augustus the Great, conquered Egypt. Another example is Empress Theodora. She married a Justinian, the emperor of Byzantine. He created the Justinian Code that governed the entire empire, and the empire was massive. It extended from western parts of Asia, North Africa, and almost the entirety of the Mediterranean. Theodora is significant because she participated in drafting the Justinian Code. Her reforms included forbidding prostitution, affording women the right to own and inherit property, And she also helped expand the rights for women in divorce cases. Now, I personally think there is a bit of irony of history that women in old Egypt possessed rights a millennia before women in Europe. But let's take a look at American women and our path to be enfranchised. In the early 19th century, there was definitely an idea of what a woman should be. A true woman was a devout, submissive wife and mother. She concerned herself only with home and family. And most adult women were married, and they had no legal standing. Women couldn't contract. If they worked outside the home, they couldn't keep their paycheck. It went to their husbands. And if a woman dared divorce her husband, he kept the children. But women began in earnest to push back against these notions. They wanted to be recognized as individuals. They wanted to have a say in their futures and the future of this country. And they believed the best way to do this, to have their voices heard, was to vote. So suffragists started mass demonstrations. They tried to get the attention of lawmakers and the press. They were mocked, and they were met with strong resistance. One event that began to push the suffragist movement happened in 1840, when women were barred from attending the World Anti-Slavery Convention, which was held in London. Now, anti-slavery was an issue many women cared about passionately. They saw it connected to their own plight. Two key suffragists, Lucretia Mott and Elizabeth Cady Stanton, were excluded from participating in this convention solely because they were women. Despite a statement from the organizers that women would be excluded, Mott and Stanton still appeared at the convention in London. They were denied entrance. They were denied participation. The product of their exclusion was a drive to action. Mott and Stanton began organizing the first women's convention in the United States. This convention is known as the Seneca Falls Women's Rights Convention, and it took place in Seneca Falls, New York. This was the first women's rights convention in the US, and although it was regional, 300 people attended. This was a multi-day convention. There were lectures and presentations. Stanton had excellent oratory skills, and she eloquently proclaimed that women must protest against a form of government that exists without the consent of the governed. She spoke strongly against the government, which women were subjected to disgraceful laws that gave men the power to chastise and imprison their wives. Stanton contested against the government that took the wages of a woman that she earned, took the property that she inherited, in the case of separating from her husband, taking the children that she loved. After the lectures, the organizers prepared the Declaration of Sentiments to be debated, modified, and adopted. The Declaration of Sentiments, which was primarily drafted by Stanton, was modeled after the Declaration of Independence, and it outlined the rights that American women should be entitled to as citizens. Of the 300 attendees, only 100 signed the Declaration. The sentiments had the support of 68 women and 32 men. This included Frederick Douglass. Now, as I mentioned, Seneca Falls was a regional convention, but it led to the first national convention just 2 years later in 1850. In attendance, key suffragists Lucy Stone and Frederick Douglass, the prominent abolitionist. There was a strong alliance with the abolitionist movement. Also in attendance at this first national convention was Sojourner Truth. Truth is a personal hero of mine. She was born into slavery, and she escaped with her infant daughter. She later became one of the first Black women to sue and win the right to recover her son from a former slave owner. In 1851, she delivered a speech at the Women's Rights Convention held in Akron, Ohio. Now, this speech was significant because she was the only woman who spoke at that convention who had ever been in slavery. And she argued for the rights of all women. She advocated for women, African Americans, which is quite dangerous for a Black woman to do at that time. Today, her dress is known as Ain't I a Woman? Because her speech was an extemporaneous speech, there's no consensus as to the precise language of the speech. Nevertheless, the ideas that permeate through the most well-accepted transcriptions all reflect that she was advocating for a vote for all women. And for the past 150 years, her speech has inspired women activists. Now, these conventions inspired women, inspired suffragists, pushed their cause, and there was a lot of energy. But we see a slowdown of the suffragist movement during the 1850s and 60s because of the Civil War. Obviously, it was hard to fight for civil rights when fighting a civil war. After the Civil War and during Reconstruction, suffragists began to disagree with the best approach to secure women's suffrage because there are parallel efforts to pass the 14th Amendment and the 15th Amendment. 15th Amendment giving Black men the right to vote. 14th Amendment was the Equal Protection Amendment. The suffragists believed that when the door opened for Black men to vote, that was actually the right time for women to do it as well. But it soon became clear that it was just too much for lawmakers to handle Black men voting and women voting at the same time. This perceived ultimatum drove tension between abolitionists and the suffragists. The 14th and 15th Amendments were ratified in 1868 and 1870. The suffragists continued their efforts. In fact, Susan B. Anthony tried to vote in the following presidential election, which was held in 1872. She was arrested and tried for illegally voting in that presidential election. And as an aside, I read this morning in the newspaper that the president intends to pardon Susan B. Anthony. Thought that was interesting. And so in 1887, we have our first suffrage vote on a national level, and unfortunately, it failed. This failure brought together two organizations. Although these two organizations had the same goal for universal suffrage, they had different approaches how to secure the vote. But with the failure in 1887, they decided to combine their efforts and they merged one organization, National American Woman Suffrage Association. The women's suffragists also shifted focus to securing suffrage at the state level. And they gained some success, particularly with the new states in the West. Wyoming, for example, was admitted as a state in 1890. And Wyoming's state constitution gave women the right to vote in its constitution. And then a few years later, Colorado, Utah, and Idaho followed suit. Over the next 20 years, there were more pickets, more mass demonstrations. Suffragists began to focus on changing the minds of men. After all, they would be the ones deciding whether or not a woman should vote. They believed they had to change the thought by men that the vote could destroy the family. Surprising to me, they also had to convince their fellow women who believed change in the societal order was not healthy and somehow against the will of God. You know, it's incredible to me that women were against suffrage. Women anti-suffragists did not want things to change, and they actually believed they were protecting women. Black women understood the power of the vote, and they believed enfranchising women would be a racial uplift. Ida B. Wells, a Black female, created many women activist groups. Wells was an investigative journalist who focused on many Black issues at the time, including lynching in the Jim Crow South. Wells and other Black women witnessed Black men being assaulted and killed. They understood that if you could not vote, you couldn't sit on the jury in a court where a perpetrator was in court. Because of what they witnessed in the Jim Crow South, Black women saw the woman's vote as a true instrument for justice. As the years passed, we see bigger mass demonstrations. For instance, in 1912, New York, one parade had 20,000 supporters. And then just 3 years later, in 1915, we see that double with 40,000 supporters. And women's work and their efforts during World War I also helped their cause. Women joined the labor force to replace men who were serving in the military, and women took visible positions as nurses, relief workers, and ambulance drivers to support the war effort. Suffragists focused on lawmakers one by one and made substantial gains in rallying support. They also focused on President Wilson, who at the time had dodged the suffrage issue. Led by Alice Paul, suffragists began applying more pressure on the president. They picketed outside the White House, which at that time was novel and audacious action. They also went on hunger strikes. Finally, in 1918, Wilson took a public position. Now, this was towards the end of his second term, and the public endorsement came when a proposal was brought before the House in January 1918. It passed the House by just one vote. The vote was then carried to the Senate, where Wilson made the appeal to the Senate. On September 30th, 1918, President Wilson made a speech before Congress in support of guaranteeing women the right to vote. Unfortunately, the measure failed. Now, the following year, the same amendment was presented to Congress 5 times, and it failed each time. But when President Wilson called a special session in May of 1919, the amendment passed the House, this time 304 to 89. That's 42 more votes than necessary. Then the following month, it went to the Senate for debate. Now, in the past, the Senate had always been the roadblock in the path of ratification. Senators were polarized on this issue. The positions of the senators from Idaho and Colorado truly reflect the two stark positions. From Idaho, Senator William Borah was against a national amendment. He thought the movement invoked, quote, too much passion. Senator Borah believed the right to vote should be decided by the state lawmakers because those lawmakers better understood the desires of their constituency. On the other hand, Senator Charles Thomas of Colorado believed the right should be expanded nationally. He believed it was not a states' rights issue, but rather it was a fundamental rights issue. His position was that when the US declared war on Germany, it sent men to fight in Europe. Lawmakers then called on the women of America to fill a void at home, and the women answered that call. Women were not asking men to change their lives, but instead they were asking to change the lives of women. This time, the amendment passed in the Senate. This then began the ratification process, which at that time required 36 states. Tennessee was the 36th state to approve the 19th Amendment. The amendment was ratified 100 years ago today. The approval was the final ratification necessary to add the amendment to the Constitution. And then on August 26, 1920, the Secretary of State certified the 19th Amendment and it went into effect. The 19th Amendment made the US the 27th country in the world to give women the right to vote. Now, obviously, this was a huge victory. The passage was a huge victory for not just women, but also for the US. It obviously changed the electorate. It enfranchised 26 million individuals, but the plight of women and their right to vote did not stop with the ratification of the 19th Amendment. Now, once ratification had been achieved, neither the general public nor politicians knew quite what to expect. What would women do with this newly acquired right? One argument by the anti-suffragists was that women would not turn out at all. Remember, suffragists had promised that women voters would clean up politics and they would enact a sweeping agenda of progressive reforms. But some predicted women would simply stay at home. This question was put to the test in November of 1920, it was a presidential year. Now, the popular vote naturally increased dramatically by 18 million more votes. About 36% of eligible women turned out during this presidential election. Overall, fewer women voted than men. But I will note that turnout varied among the states. For instance, if you look at Kentucky, the turnout for women was 57%, but in Virginia it was 6%. Also, women tended to turn out more in swing states. Now, it took some decades for women's turnout to grow, but we will see later in this presentation, it now exceeds men's turnout. Another matter was whether the vote would change women's lives. It did, slowly but surely. On the legislative front, in 1921, Congress passed the Shepard-Towner Act. This act was passed to address the shocking rates of infant mortality. It provided the states with about $1 million a year to fund maternal and child health clinics. This legislative achievement likely would not have passed had women remained disenfranchised. Another example is in 1922 with the passage of the Cable Act. This provided a path to the voting booth for women who had lost their U.S. citizenship by marrying a foreign national after 1907. Additionally, women's suffrage was a key precondition to women serving in elected office and exercising a greater political power. At a local level, the 19th Amendment spurred numerous female firsts. For instance, in Yoncalla, Oregon, voters replaced the entire city council with women. The New York Times clip said, "Sex uprising in Yoncalla." At least 22 women within the 3 years after the passage became mayors in small towns across the US, including Langley, Washington, Salina, Utah, Red Cloud, Nebraska, Goodhue, Minnesota, Fairport, Ohio, and Duluth, Georgia. And then we also saw successes on a state level. In 1920, teacher Eva Hamilton became the first woman elected to the Michigan Senate. New Mexico elected its first woman to a high-ranking state office when in 1923 it elected a woman Secretary of State, and at least 5 states thereafter, including Texas, did the same. Indiana elected the first female state treasurer in 1926. And at the federal level, we also see some progress. In 1928, Ruth Hannah McCormick won an election in Illinois as a Republican. She advocated for prohibition, farmers' rights, and isolationism. Another example is Ruth Bryant Owen. She won in Florida as a Democrat, and she earned praise for her advocacy of child welfare as well as Florida's agricultural interest. The successful passage of the 19th Amendment helped give impetus also to other social issues, including positive impacts on children's education, as well as the birth control movement. In these ways, the 19th Amendment expanded opportunities for women to participate in governance and to change the trajectory of social welfare policy. But despite these great transformations, and they were truly great, momentous transformations, the legacy of the 19th Amendment in short term turned out to be complicated. While this helped women get into elected offices, participate in major political parties, it still left many women outside the halls of power. And at the time, many people asked a question, and I think it's a fair question: which women were enfranchised by the 19th Amendment? Enfranchisement was not for all practical purposes extended to poorer women or minority women due to burdens disproportionately affecting women, such as poll taxes, literacy tests, and long residency requirements. States retain the ability to set the laws in primaries and at the polls. They often bow to party interest or racial bias or class bias. Poll taxes, we know, certainly burden women disproportionately. In families, the male head of household controlled the family finances, and not every husband or father was willing to pay the poll tax on behalf of his wife or daughter. Women of color who succeeded in registering and voting, which immediately after the 19th Amendment was very few, unfortunately inspired fresh efforts to suppress Black voters. Black women were blocked by fraud, intimidation, and violence. Most African American women and Latino women were blocked from exercising their right to vote until 1965, when the Voter Rights Act was passed. And Native Americans who were not considered citizens didn't have the right to vote until 1924 with the Indian Citizenship Act. Some states still limited Native Americans' right to vote, even after this act. New Mexico became the last state to enfranchise Native Americans in the state, and that was in 1962. Asian American women could not vote until a series of reforms, roughly starting with the passage of the 1952 McCarran-Walter Act and ending with the Voter Rights Act of 1965. These statistics show there was much more work to be done for all women in the period immediately following the 19th Amendment. And we start to see that in the 1950s and the 1960s, and ultimately with the 1965 Voting Rights Act. The 19th Amendment did not immediately fulfill all of its supporters' hopes. We know that. But its impact has grown over the past century. Suffragist Maud Wood Park remarked that it was hardly reasonable to expect women voters overnight to straighten out tangles over which generations of men had worked in vain. Now, we've taken a short look at our suffrage journey, and I want to take a brief moment to look at suffrage in other countries. Most countries did not even grant suffrage to women until the late 1800s and early 1900s. In 1893, New Zealand was the first country to grant women suffrage in national elections. This right was even extended to Indigenous women. And what was very surprising to me is Russia and Germany, two male-dominated nations, historically male-dominated nations, granted women the right to vote in 1917 and 1918. Both granted suffrage before the United States did. And here I have listed some countries that granted suffrage to women before the United States. I mentioned Germany, Russia, you can see Canada, Australia, and there's other nations that also granted suffrage to women before the US, and that includes Iceland and the UK. Now let's take a look at some more recent women's suffrage victories. In the Middle East, religious and cultural beliefs prohibited many women from voting until recently. Iran, Algeria, Zimbabwe, and Jordan granted women the right to vote in the 1960s and 70s. Kuwait granted women suffrage in 2005. The UAE followed suit in 2006. Saudi Arabia is the second to last country to give suffrage to women, and that happened in 2015. Afghanistan granted women the right to vote in 2014, and they came out in record numbers. The last holdout, Vatican City. Vatican City still does not allow its female citizens to vote. And remember, Vatican City is not part of Italy. It's an independent territory. It's actually the smallest country in the world. The Catholic Church does not allow women to be cardinals, so women are not allowed to vote for them. But there is some thought that things may change under the current progressive Pope Francis. Despite its early limitations, the 19th Amendment over the past century has indeed helped women assume a role in public affairs that would be hard to imagine without its passage. I think it's fitting for me to conclude with statistical data to show you how much of an impact the 19th Amendment has had, and even the efforts since it has been passed. In 2016, Hillary Clinton was selected by Democrats as its presidential nominee. This was the first time a major party nominated a woman as its presidential nominee. We now have 3 vice presidential candidates by a major party. That's 4 women at the top of the ticket for a major party during a presidential election. I think that's pretty significant. We have 3 former secretaries of state, Madeleine Albright, Condoleezza Rice, Hillary Clinton. They served as secretaries of state, which is the most senior cabinet position in the White House. As of July 2020, women occupy 9 governorships, and the mayor of Washington, D.C. is a woman. Women hold 26 seats in the U.S. Senate and over 100 seats in the House. This is the highest proportion of women serving in Congress in history. The current Speaker of the House is a woman, the only woman who has served in the Speaker position. According to the National Association of Women Judges, 31% of the Texas state judiciary are women. And on the federal bench, women comprise 27% of sitting judges, 33% of active judges. There are 3 female justices currently serving on the U.S. Supreme Court and 3 sitting on the Texas Supreme Court. A century after ratification, it is clear that though the 19th Amendment did not perfect American democracy, it advanced gender equality in momentous ways. I think it's also significant for me to note that women have been determining our leaders and our presidents in the past 9 presidential elections. Since 1980, the voting gender gap has completely reversed, with a higher proportion of women voting than men. According to the Pew Research Center, in the last presidential election, turnout for women was 63%, 59% for men. And we also turn out in higher numbers during midterms. In this year's election, the most sought after vote is the woman's vote. This November, women will likely select our leaders at all levels, local, state, national, something that could not have been realized without the passage of the 19th Amendment. And I will end on that note. Thank you very much for having me. And I will now turn it over to Professor Kaneki Jefferson. Thank you again.
Okay, wonderful. Thank you so much, Marie. That was terrific. Hopefully you all can see my screen and my slides. And I want to really pick up exactly where you left off in thinking about those statistics. My focus today is going to be on suffrage and shortlists. And I think those statistics and, of course, what we're all here today to do, which is to honor the anniversary of women's suffrage, is absolutely a reason for a celebration. But also it's very much a call to action. Again, just to introduce myself, I'm Renee Kaneki Jefferson. I'm a professor of law at the University of Houston Law Center, and I hold the Joanne and Larry Doherty Chair in Legal Ethics. I've been there since 2016. A decade before that, I was a professor at Michigan State University. I teach constitutional law, legal ethics, and a special seminar on gender, power, law, and leadership. And much of my research, especially as of late, has been devoted to women who were shortlisted for the US Supreme Court, especially those who were shortlisted before Sandra Day O'Connor, the first woman to sit on the court, arrived. And here's how I'd like to spend the 45 minutes or so I have with you this afternoon. I'll begin by speaking a little bit about the book's origins. Why did I decide to start writing about shortlists? And then I'll share with you some history from the book itself. I'll try to highlight some moments that are very relevant to our celebration of suffrage today. And then I'll conclude with some concrete strategies about what we can do to make those statistics that Marie just gave to us reflect the number of women who are entering the profession and who are eminently qualified to hold positions of leadership and power. It is, of course, wonderful that about a third of the judges in Texas are women, and about a third of the judges in the federal courts are women, and that we have 3 women on the Supreme Court. But I want to also point out that women have been entering the profession in numbers equal to men for decades. There certainly are enough women that are eminently qualified to hold these positions, not just on the court, but in all leadership and power positions, whether we're talking about managing partner or a lawyer who is arguing cases in court, or a public defender's office, or of course the judiciary. We should see women in equal numbers in all of these roles. And so at the end of our time together, I'm going to suggest some ways that the next time we come to celebrate an event like this, we will see statistics that look even brighter. So, of course, it is a measure of progress, absolutely, that we have had 4 women sit on the US Supreme Court. of course, 3 sitting there currently. And I don't want to diminish that in any way, but I also want to point out that this is less than 3% of the number of men who have served on the US Supreme Court over time. So while 4 seems like a lot, some might even say a critical mass, it really pales in comparison dramatically to the number of men who have served in this role. And I hope you noticed when Marie was sharing her statistics, there was a number she did not mention in terms of how many women have served in that role in the United States. And it's the Chief Justice. We've never had a Chief Justice on our Supreme Court who is a woman, although numerous countries around the world have had women in that role. And so I think that's unfortunate, and it's something that hopefully will change in the not too distant future. So yes, of course, this is progress. This book found its origins in unpacking that progress a little bit. And in fact, when the most recent women who joined the Supreme Court, Elena Kagan and Sonia Sotomayor, were appointed by President Obama in 2009 and 2010, you might recall headlines like these. Sotomayor, single Supreme. The article wondered who's going to escort her to the fancy Supreme Court dinners. Then comes the marriage question, a labor market punishing to mothers. The Supreme Court needs more mothers. Or one of, I don't know, either the worst or the funniest. Who wore it better when Elena Kagan and Sonia Sotomayor happened to wear strikingly similar blue blazers to their Senate confirmation hearings? And it was articles like these that led a wonderful friend and colleague of mine. We were teaching at Michigan State at the time, Professor Hannah Brenner Johnson, who is now the Vice Dean of California Western Law School. The two of us started having conversations, mostly in the hallways, wondering about this coverage. We didn't recall when President Bush had appointed now Chief Justice Roberts and Justice Alito to the bench, there was similar focus on their fashion or their attire or who would be their date for a fancy Supreme Court dinner. And rather than just sort of wonder and speculate about this, we're academics, so we decided to study it. And we created a media study in which we looked at every single article written by the New York Times and the Washington Post, going back to the early 1970s, mindful of the feminist movement at the time, up until the confirmations of Sotomayor and Kagan. We coded the articles for lots of different variables, all related to gendered coverage. And perhaps unsurprisingly, we were able to show that in fact, the media is more likely to focus on specifically female attributes like clothing, family, their marital status, and that sort of thing. And I'm not here to share more about those study results with you today, although you can read the study. It's in a law review article, and there's the title and citation for it if you want to take a quick note about it. But what I am here to share with you is something that we found in that media study. One of the articles, and even though we had wonderful research assistants helping us, Hannah and I read every single one of those newspaper articles, thousands of them, and one of them we found was written in 1971. And I've brought that article here to show you now. It appeared in the New York Times in October of 1971. The headline read, "Potential High Court Nominees." This is when President Richard Nixon faced not one, but 2 vacancies simultaneously on the court. And for the first time ever, 2 women appear on his short list of 6. One was Sylvia Bacon, and one was Mildred Lori Lilly. And I've highlighted or called out a specific line, you can see there at the bottom of the article, where the article focuses on, in addition to her qualifications, the fact that she had no children and had maintained her bathing beauty figure even in her 50s. This sort of coverage was not reflected in the descriptions of the male nominees. There was no discussion of how Herschel Friday filled out his swimming trunks, for example. This article sparked outrage. There was a letter to the editor calling out the very sexist coverage. But for us, as we were looking at it, well, first of all, it definitely supported the media study. But then we wondered, who's Mildred Lilly? Why haven't we ever heard of her before? Who's Sylvia Bacon, the other name on the list? And how many other women were shortlisted for the US Supreme Court before Sandra Day O'Connor became the first woman on the court in 1981. And that is the origin of this book. And it led us to travel across the country, visiting presidential archives and libraries holding the personal papers of these women to find out that answer. The answer is 9 women. 9 women were officially considered on presidential shortlists before Sandra Day O'Connor became the first. Want to take a guess at who the first president was to consider a woman for the Supreme Court? I can give you kind of a hint, although I don't know, this might be a stretch. From when Marie was speaking, she mentioned Marie Maud Wood Park, who was a mentor of the woman who was the first to appear on a president's shortlist. And here's the shortlist, and here's the name. So this is from President FDR's archives. The date's August 3rd, 1937. For those of you who are historians, you might recall that 1937 was the year that FDR was considering expanding the number of justices on the Supreme Court because he was unhappy that the court was continually striking down his New Deal legislation. He ultimately never needed to increase the number of justices, but this was the list that was created when they were considering doing this. And on this list of names appears Florence Allen of Ohio. And Florence Allen was mentored by Maud Wood Park as part of her work and the suffrage movement, and I'll share a little bit more about that in a second. So this is where our history in the book Shortlisted begins. It begins with Florence Allen, and it goes up through the nomination and confirmation of Sandra Day O'Connor, and then continues through the other shortlists from Reagan. There was a question submitted in advance about why we stop there. And it's not because there aren't many other stories that need to be told, but it's because we wanted to focus on these untold stories, this part of our American history, our Supreme Court history, and the history of women's rights in this country that had never before been told. Here is Florence Allen. This is the photo I had on the opening slide to my talk. And so there she is. She's holding the flag. She was extremely active in the women's suffrage movement in Ohio. And in fact, that's how she ends up as someone who is a contender for the US Supreme Court. After she travels all of Ohio, encouraging women to come out, and encouraging the men of Ohio also to support women's suffrage, she turned around and she asked for their votes. And she won overwhelmingly, being elected to the Ohio Supreme Court because of the votes of women. What I want to do now is turn to share a little bit more about Florence Allen, and then also the untold her story of the Supreme Court. This cohort of shortlisted sisters, how they ended up as contenders on a president's shortlist. To be sure, even though they were not ultimately selected for the US Supreme Court, to even be floated as a potential candidate, they had to be selected over and over again, professionally in their lives, often into positions that had never before been held by a woman, and often in positions where the men who held them were actively trying to keep women out. Their stories deserve to be told in their own right. But what we found as we wrote this book is that there are lessons from their stories and their lives that are very relevant today as we think not just about celebrating this history, but also a call to action so that we see women and minority women in particular represented in equal numbers to men in positions of leadership and power on the Supreme Court and beyond. So I'll say some more about those strategies in just a moment, but first let me introduce you to these women. And here are our 9. I want to focus on each one individually. Florence Allen, you've already heard a little bit about, but here she is in her judicial robes. So after she goes to the Supreme Court of Ohio, FDR in 1934 places her on the Sixth Circuit Court of Appeals. She becomes the first woman to sit on a federal court of appeals. When she arrives, there was no bathroom facility for her that was appropriate, but she had to borrow and they had to sort of corner off one of the men's restrooms until federal funding could be secured to build her an appropriate restroom. And I mention that because often for all of these women in the study, and they in many ways could not be more different in terms of their political views, their social views, their particular trajectories, but one thing every single one had in common was being told at one point when they were interviewing for a job that they were eminently qualified, that the employer wanted to hire them, but that they didn't have appropriate facilities for women. And so it's something that perhaps we take for granted, although maybe is also still a metaphor for structural impediments that still remain today that keep those numbers looking like they do, where women represent about a third of the positions of leadership and power, when in fact they are entering the profession in equal numbers. So Florence Allen arrives. She secures bathroom facilities for women in the courthouse, although she is not allowed to join her male colleagues for lunch. They dined at an all-male dining club, and she would warm up her meals on a hot plate that she kept in her office. The news accounts about her appointment by FDR to the court included coverage that some of her male colleagues on the court fell ill and had to take to bed over the news. Nevertheless, she rose to become a very prominent, highly respected jurist. And not only was she considered by FDR, but she was also considered by Hoover and Truman. And the presidential archives and her personal papers reveal that she had broad support across the country for her potential appointment to the Supreme Court. And I have to imagine, and I wonder about this a lot, and we reflect on this in the book, what would professional life have looked like for women, and would doors have been more easily opened if she had been moved into such a nationally prominent role as the US Supreme Court in the 1930s? I think it would have had a profound impact. So that is Florence Allen. The next woman to appear on a president's shortlist was Zoya Menshikov. She was considered by both JFK and LBJ. And the reason why is because Nick Katzenbach, who was the advisor to both of those presidents, had served on the faculty with her at the University of Chicago. He considered her to have a formidable legal mind and to be an incredible candidate for the court. She was the first female law professor at Harvard Law School, the first female law professor at the University of Chicago Law School, and the first permanent female dean at the University of Miami Law School. Also, equally notable amongst her accomplishments, she was the first female reporter for the American Law Institute and very much spearheaded what we now know today as the Uniform Commercial Code. And especially now in a coronavirus world where all of us have been looking at our contracts perhaps in a different light, just understanding how influential of a role she played in American law and American life. She is one of my favorites because as a law student, I walked past her portrait every single day in the echoing glass, steel, cold, gray hallways of the University of Chicago, and I never really felt like I had much in common with her. But when I discovered that she fit into this study, I had to go to her archives. And I've held her personal papers. I've held the lecture notes she prepared for class. I've read articles about one of the New York newspapers early on in her work when she practiced law featured the life of a lady lawyer, and she was in a ball gown, and it included details like how much she would spend on her alcohol and cigarettes. And learning about her in that way, seeing the way she prepared for class, reading letters that she wrote when she was mentoring former students like Carol Moseley Braun, I suddenly saw her in a new light. And although I never met her in person, she passed away before I had the opportunity to do so, she's become very much a mentor to me. And that's one of the lessons from this book, is that these stories are important, not just to be remembered, but also because they can offer really meaningful mentorship for the generations of men and women coming after them. Next in our study is Mildred Lilly. You've already heard about her. She was in the New York Times. Remember, she's our bathing beauty figure. In addition to, I guess, taking good care of herself, she also was a very prominent judge in California and came very close to being the woman plucked off of Nixon's shortlist. But Nixon really was using his shortlist for political purposes, not so much because he fancied putting a woman on the court. And in fact, we've listened to his Oval Office tapes, and he would say things like, "I don't even think women should be allowed to vote," which I guess is especially offensive given that we're celebrating women's right to vote today. He very much wanted their vote, though, and he believed that it would increase the women's vote if he would go through the gesture of putting women on his shortlist. And again, privately in the Oval Office, he said that he was hoping that the American Bar Association would rate her as unqualified in their judicial rating process, and that would mean he wouldn't actually have to appoint her. And that, in fact, is what did happen. I will just tell you as a footnote in history, though, years later, his White House counsel, John Dean, said that he took the resume of Mildred Lilly and Sandra Day O'Connor and put them side by side and felt that Mildred Lilly was as qualified, if not more so, and would have been a very well suited justice on the Supreme Court. But that was not the purpose for which Nixon had actually included her on his list. You might recall that Nixon goes on to appoint the man who will eventually become Chief Justice, but Justice William Rehnquist, and also Justice Powell. An interesting aside, as part of the vetting process, Rehnquist was on the team that interviewed and vetted Lilly. He actually carried her suitcase in when she went through the interviewing process. And after her candidacy is tanked, he goes on to becoming the one who's selected. Sylvia Bacon was also on Nixon's shortlist. Sylvia Bacon was a judge in DC. And the concern for her, although it was a little bit intriguing for Nixon as well, was her age. She was 39 at the time, and they determined she was too young, although, of course, male justices younger than that had served. And I can tell you that she goes on then to be repeatedly considered for different federal judgeships, not just for Nixon's Supreme Court, but by subsequent presidents. And in the presidential files, the notes go from being too young, too young, too young, to suddenly she's too old, too old, too old. And that was another lesson that we learned in writing this book, is that age often becomes a proxy for sexism, in that women are too young and inexperienced, the men are considered promising, and then the women are too old and the men are considered distinguished. And so age has become another barrier for women and why they remained shortlisted for so long, even though they were considered for decades before Sandra Day O'Connor made it to the court. Next in our lineup is Carla Hills. She was shortlisted by Gerald Ford. She served as his Secretary of Housing and Urban Development. In her oral history, she reflected that Nixon asked her whether she wanted to be considered for the Supreme Court, and she declined. She said she was happy to remain in her role at HUD. And that was another observation taken away from this research. Sometimes shortlisting happens because the shortlist is being used in the way Nixon was for political or other purposes. But sometimes the shortlisting happens when women themselves shortlist, when they think they're not yet qualified or they can't balance things to pursue a particular position they're being considered for. And one of our recommendations in the book's conclusion is for women to be mindful of that and to try to avoid self-shortlisting. Judge Kearse, she was on Reagan's shortlist. For those of you who are wondering, how many women are left? We are now at Reagan's shortlist. And of course, we know that Reagan goes on to select a woman from his shortlist. When he was campaigning for president, he made the pledge and promise that he would put the first woman on the Supreme Court, which is interesting to now reflect that we have another candidate for the presidency, Joe Biden, who has made a similar pledge, not just to put a woman on the Supreme Court, but to give us our first African-American woman on the Supreme Court. It could have been, should have been, Amalia Kearse. Judge Kearse sits on the Second Circuit Court of Appeals. Before she was appointed in that role by President Carter, she was a prominent, highly successful partner in a Manhattan law firm at a time where women and minorities were not partners in law firms. She's a graduate of the University of Michigan Law School. And I will take a moment here just to reflect on the fact that even though you haven't seen the whole list yet, what you will see momentarily is that Judge Sears is the only minority woman that appears in the study. We have no idea what we would find when we set out to determine how many women have been considered for the Supreme Court before O'Connor. But what I will say now, since we know the number is 9 and that only 1 is a minority woman, that our study very much reflects the continued barriers and hurdles that are placed on minority women in particular when they are pursuing positions of leadership and power. And one story I'll just share about Judge Sears that I think reflects this. After her swearing in, her investiture ceremony, she went to celebrate as one would over dinner. And she arrived at the restaurant first with her mother. And we know the story because it appears in her oral history. Her mother was a physician, so also really incredible. And they arrived, they're seated, and then the next guest shows up, and the maitre d' that's showing the next guest in, the guest says, is Judge Sears here yet? And the maitre d' says, no, just these 2 ladies. Like, as if they just couldn't possibly be that one of the 2 women could have been the judge. And so I'll share a little bit more about Judge Sears and how she ends up on the Second Circuit when I conclude with some strategies at the end. So keep a placeholder to learn a little bit more about how she ended up where she did. But for now, I'll tell you a little bit more about Reagan's shortlist. It also included Joan Dempsey Klein. Judge Klein was a judge from California. And one of the stories I like to share about her, she was extremely active in promoting women in the profession. And not all of the women in the study were. In fact, some of the women campaigned against the Equal Rights Amendment. Some obviously were campaigning for suffrage, like Florence Allen. Joan Dempsey Klein was a woman who was very much an advocate for women lawyers. She was a founder of the National Association of Women Lawyers and Women Judges. And one of the stories I like best to share from her oral history is this. And I can't imagine what it would be like to know that you're on the shortlist for the Supreme Court and to come so close and to find out the news that you're not the one. I have to imagine that comes with a range of emotions. But for Judge Klein, she channeled whatever she was feeling into a positive force to champion another woman, Sandra Day O'Connor, and she testified on her behalf at her Senate confirmation hearings. And not only did she talk about O'Connor's qualifications, but she also testified about the additional barriers and hurdles and difficulties O'Connor would face as being the first woman in that role. And coming alongside to champion in those ways, I think, is a real model and example that men and women can still follow today when we think about championing other women to move into positions of leadership and power. Susie Sharp. Susie Sharp also was on the shortlist with O'Connor. She was the first female justice on the North Carolina Supreme Court and the first elected Chief Justice for any state Supreme Court. So even though the US Supreme Court has not had a female chief, the state Supreme Courts are much better in that regard, and there have been female chiefs on many state courts. Susie Sharp was the first to be elected in North Carolina. She was a woman of real contradictions, as this quote says. On the one hand, she held herself out as being completely career focused. When she would speak about being a female judge, she would advise women, you can have one or the other, not both. You can have a career or you can raise children, but if you try to do both, you won't be able to do so successfully. Very much a contrast to Carla Hills, who, when she was appointed by Ford to go to HUD, took her 4 children in tow, and Life magazine did a huge spread on how she was balancing both being a mother and also her career. That was not advice that Susie Sharp would have given. Susie Sharp lobbied against the ERA. Susie Sharp was an avowed racist. And so discovering more about her, it was hard to reconcile some of her views as we were researching this project. And yet we also found her very intriguing. Her archives held at the University of North Carolina are overflowing with all kinds of notes and everything from the tips she would pay to a bellhop to how she would apply her makeup and her exercise routine. And she had this very, very profound love life. She would collect poems. And even though she was an avowed racist, on the bench, she was the first judge to order the desegregation of a private golf club in North Carolina. And so she lived out these contradictions, but lived them out in ways where she still adhered to the rule of law. And I think that's ultimately why she was on the short list for Reagan. One of my favorite quotes from her is that she felt she was oft the bridesmaid and never the bride with respect to the Supreme Court. And that brings us to the last woman who was considered for the court before O'Connor joined it, and that's Cornelia Kennedy. She came the closest. She was actually officially interviewed. It came down to her and O'Connor. At the time, Kennedy was serving on the Sixth Circuit. She was a judge from Michigan and then was appointed to the Sixth Circuit when Florence Allen left. Remember Florence Allen and her hot plate? That hot plate was passed on to Cornelia Kennedy. So when Judge Kennedy arrived at the Sixth Circuit, she had a bathroom to use, but she still was not allowed to dine with her male colleagues. Instead, she used that hot plate until she was able to convince her male colleagues to stop frequenting that luncheon destination until they included women, which they did. And I mention that because it might seem subtle, it might seem insignificant, but it's very much a structural change that the men could come alongside and support her in that would allow her to be a part of that important professional community, which is the bonding and networking that happens over a professional lunch. So those are our women. Now I want to take a step back and share a few lessons. What might we do to transcend the short list, if you will? And so I'll share a couple and then conclude by suggesting how I think this ties into the work that remains with respect to women and the right to vote. First, I want to share this definition with you. This is also not something we expected to find in this research. When we set out to do it, it was very much going to be a history of these women's lives. But as we read over and over again how they were shortlisted, we came up with a definition, if you will, of this phenomenon that we observe. Being shortlisted, qualified for a position, but not selected from a list that creates the appearance of diversity, but preserves the status quo. Richard Nixon was certainly the worst offender, if you will, in this regard. But I imagine that this is a phenomenon that most women can identify with, whether we're talking about being considered for the Supreme Court or you're talking about the selection process for any position of leadership or power. Often an organization will claim to care about diversity and equality by saying, look who we considered. But we know that they aren't selecting women in equal numbers to men from those lists because we can look at the statistics and they tell us otherwise. So what can we do to move away from this shortlisting phenomenon? And to be sure, you got to be on the shortlist to be selected. And we want the shortlist to be very diverse, but we don't want that diversity tool to become itself a mechanism that perpetuates the status quo. Now, because one way to do this would be, I guess, to do what presidential candidate Joe Biden has done. He's given us a female vice president nominee, and that's because he had an all-female shortlist, and he's promised that for the Supreme Court. So, I mean, one way to do that is to create an all-female shortlist, but I think that that relies so much on the particular person who's making the selection in the moment, and it risks ignoring and avoiding more lasting and enduring structural change. So let me just give you two examples from this research about what I mean by enduring structural change. And the first comes from President Carter. You might have noticed that I didn't mention Carter amongst the presidents who shortlisted a woman for the Supreme Court. And if you know anything about Carter, that would be very surprising until you also recall that he never had a vacancy to fill. Had there been a vacancy during his presidential term, it's widely thought by historians that he would have put a woman on the Supreme Court, likely Shirley Huffstedler, who was serving as his Secretary of Education. But what he did do was completely diversify the federal judiciary in ways that no president before him had, including putting RBG on the DC Circuit Court. And he did it not by promising to put women on the courts in some sort of, I'll just have short lists of women, but he did it through an executive order that effectuated structural change. This executive order established judicial commissions around the country, a dozen or so of them. The commissions themselves were diverse in makeup. They included men, women, and minorities. They were charged with vetting judicial applicants who were also diverse, men, women, minorities. And importantly, amongst the qualifications in the vetting process and questions that were asked to the applicants, they had to talk about their commitment to diversity. And they had to show that they had a demonstrated commitment to diversity, whether men, women, or minorities. One of the members of one of those commissions is someone I told you about already. You guessed who? Judge Sears. Judge Sears was a member of one of those judicial selection commissions. And then, of course, she goes on to be selected by a commission for her appointment to the Second Circuit. And I really fear that without this sort of structural change in place, we might not have seen any minority woman in this study. And this, I think, shows how profound a structural change like this can be. Now, it's not to say that all of us are going to be able to issue an executive order like the president did. So let me give you another example of structural change that I think anyone who's in a position of leadership can implement. This is a photo from an annual meeting for law professors, the Association of American Law Schools. Every year except this year, because it will be virtual, they convene together, and this is part of the reception hall area. Soya Menchikoff, she was the second woman shortlisted, was the first woman to be president of this organization. It was in the 1980s. And she was not a particular activist in the feminist movement, didn't come out in support of the Equal Rights Amendment or anything like that, was not known to be a strong feminist, but she observed that women were not attending the annual meeting. And when she inquired, she learned, even though she did not have children of her own, that women who did and had caregiving responsibilities could not get away because of the timing of the meeting. It happened immediately after Christmas through New Year's. And so she changed the meeting time. She moved it to after the holidays, and suddenly women could attend. And why does this matter? Because it's not just an annual meeting, but it was also, and it is an enormous networking opportunity, a place to potentially find connections for publishing or for new job opportunities. And in fact, my co-author, Hannah, and I very early in our career won a writing competition award together at this annual meeting that we could only attend because it happened after the holidays. We were raising toddlers at the time. But for winning that competition, we might not have been spurred on to engage in this research and have this book selected by a publisher to go out in the world. And so that small change of just thinking about the timing of a meeting that will allow caregivers, for primarily women, to participate can have a profound impact in their professional trajectory. And there's, of course, Soya Menchikoff to honor her and her legacy in that regard. Here's all the women. I'm not to say that if you follow all the strategies in our book that we'll have a Supreme Court that looks like this. Although why shouldn't we? I mean, I used to sort of chuckle when I would hear the quote from RBG, when will you be happy, with the number of women on the court, when there are 9. And, but why not? There were 9 men on the Supreme Court for over a century. And so why shouldn't we have a court that looks like this? And again, I'm not here to say that if you read the book and follow all the strategies that you will end up on the Supreme Court, or we will end up with the Supreme Court like this. But I am here to say that reading the book, I think, offers additional strategies beyond what I just shared today. I don't have time to share them all. And importantly, I think we'll ask us all, or call all of us to ask, why shouldn't we have a court that looks like this? And of course, because I'm based at the University of Houston, I want to be mindful and pay respects to the only court that I'm aware of in the United States that was all female for at least a moment. And that's the Supreme Court of Texas. So the slide I just showed you is a slide I took the photos and superimposed on the Supreme Court of all men. This is an actual photo of the Supreme Court of Texas presiding in 1925. Governor Neff did a special appointment of 3 women lawyers because all of the male justices were disqualified from hearing a case that involved, they were all members of the Fraternal Order of Woodsmen. It was a land dispute. And so the men were all disqualified. And so the governor created the first all-female court for the Supreme Court of Texas. Yeah, that was 1925. Ruth Bazile, Hortense Ward, and Hetty Kenigsberg. If you go to the Supreme Court of Texas, you can actually see this photo hanging in the back of the court. I think they should move it to the front, but at least it's there, and it reminds us of that history. Their appointment lasted only for that case. It would not be until 1982 that Justice Ruby Sonduck was appointed to the Supreme Court of Texas, and not until 1992 that Justice Rose Spector was elected to the Supreme Court of Texas. But some important Texas history, to be sure. And so now let me conclude my time with you by suggesting some lessons we can draw from this shortlisted history that relate to suffrage. And an important one is remembering the history of the suffrage movement, which I appreciate that Marie did such a wonderful and compelling explanation for us, reminding us that it did not include voting for all women. And in fact, in the negotiations, Elizabeth Cady Stanton would have sacrificed the vote for minorities if she could secure it for white women. Ida B. Wells was asked to march the back in marches for securing the right to vote. And one lesson I drew from writing this book, and something that we spend a fair amount of time on in the book, is this repeated error of the feminist movement time and time again in this country, where securing rights for women doesn't necessarily and hasn't always necessarily meant securing rights for all women. I hope, as we see our country right now in this moment of really coming to terms with racial injustice and trying to grapple with structural impediments, that perhaps we will finally move beyond that. But I think it's an important reminder, both in terms of the history of the suffrage movement, but you also see it reflected in the makeup of the women who are profiled here. Another observation I would make is, well, what do we do next about all of this? And thinking about this right to vote that we have. And what I want to say is we need to think about those same sort of structural impediments and how we remove them. And maybe it means changing laws, and maybe it means heavy lifting that might feel daunting or impossible to an individual, but it absolutely also means reaching out to your neighbor, offering to mask up and hand sanitize and drive them in a car to a polling place, or mask up and hand sanitize and keep an eye on their kids playing in the backyard in a socially distanced, safe, responsible way so they can go to the voting booth. It means encouraging people to mail in their ballots if they can, or to do early voting like is allowed in Texas. And it means not just taking a moment right now to celebrate this history, but thinking about how each one of us can actively exercise our right to vote and take a small but profound step to remove structural barriers that might be in someone else's way as they are trying to exercise their right to vote. And that's how I think we can both celebrate suffrage and women being on short lists, but we also can answer that call to action for how we expand suffrage more broadly to all women, and also how we see more women move from shortlisted to selected, whether on the Supreme Court or in any area of professional life. And I'd like to now turn things over to Justice Bourlier, who is one of the women who was not just shortlisted, but has been selected for the judiciary, and allow her to also share her observations and reflections with us today.
Thank you so much. I want to start by thanking Mariann Sears and Joe Lawson and Professor Jefferson and Marie Jameson for this wonderful presentation. I've learned so much, and thank you to everybody who has attended virtually. I am here to share with you a little bit of my experiences, both as a woman and as a minority woman in running for office, being elected to office, and why I think it's important that we have more diversity in our elected officials. In all honesty, when I first started thinking of running for office, my mind was totally racing, and I imagine it's somewhat similar to what a lot of mothers particularly are feeling right now with COVID and schooling. I am a single mom. I have a very active child who plays lots of sports, and my brain instantly was trying to figure out, how can I do this? How can I find the time and energy to take him to practice, make sure his homework is done, start a new law practice, campaign, live a life, essentially. And I wasn't sure how that would be possible. I think that just like Professor Jefferson was saying, a lot of the focus on women who were shortlisted back then it was on their roles as mothers or what other obligations they had. And in my life, it was a very, very real issue. I was extremely lucky in having a group of women who were campaigning with me, who basically all just pitched in and said, we're going to do this, we're going to help you. We're going to do whatever we can. I sat down and spoke to my son. He is now 11. So back then, he was a couple years younger, and he was all for it. He thought this was an amazing thing to do. He thought it was really cool to see his mom and people that he knew running for office and trying to see what we could do to effectuate some kind of change. And in all honesty, when I first thought of running and I thought of what I could bring to the bench and the diversity I could bring to the bench, my focus was really on my background. I had been a public defender for most of my career. I had been a criminal defense attorney for most of my career. I had a focus in mental health and in felonies and appellate, and there was a point of view and a sort of experience that I could bring to the court that had been missing. We didn't have any criminal defense attorneys who were on our court, and I thought it was a hole that the court was lacking. I didn't really, in all honesty, think too much about the woman aspect or the minority aspect when I started campaigning. And I think part of that is because I was fortunate growing up, in the beginning of my life when I lived in West Texas, I definitely got the comments about how, my eyes were slanted and how the food I ate was different. And everybody assumed that I would be good at math, and everybody assumed all of these, base stereotypes of Asian Americans that they had grown up with. When I moved to Houston, and as I kind of went through my schooling and when I went through college and law school, I didn't get that a whole lot. I had a lot of support from my friends and my colleagues. I didn't really, I'm a Korean American, that was part of who I am, but it didn't really separate me a whole lot until I started campaigning. Nothing prepared me for the first time when I was campaigning, and I guess that was 2017 when I started, for the first person who remarked to me that my English was so good. Or for the people who asked, well, don't you have to be a citizen to run for office? And those sorts of comments, really, it struck me at that point how, there was such an absence of Asian Americans on the bench. And it really kind of inspired me to keep pushing forward with my campaign and to keep reaching out, especially to the younger generation. I remember going to the University of Houston for an event, and I had these young students coming up to me, these young Asian American females, and saying, you don't see people like us who run for office. And they would tell me, culturally, we don't speak up. We follow rules. We are generally kind of in the background. And it kind of, I was very humbled by those interactions, and it did inspire me to keep going with my campaign and just to keep reaching out. Just as a matter of numbers, and I know that Professor Jefferson and Marie Jameson both talked about this, but the Office of Court Administration has some numbers that were released through September 1st, 2019. So it doesn't, take into account everything. But of the numbers that were reported, of the 78 of the 80 seats of the courts of appeals, roughly half are women. I'm on the 14th Court of Appeals, and of the 9 justices on the 14th Court, 5 are women and 4 are men. We have a female Chief Justice. I've been very fortunate to have a lot of strong women in my court that I can go to, and everything from how am I balancing something in my personal life with my child to anything work related. I've been very fortunate to have them as mentors and as resources. At the district court level, according to this OCA, it shows that there are 170 women and 292 men. So there's a little bit more work to be done there. What was most striking to me was on the Court of Appeals, if you break down the numbers that were reported, there are 2 African Americans, 1 Asian, which is me, 14 who identified as Hispanic or Latino, and 61 who identified as white. Now, we might wonder, why is that important? Why does inclusion matter? Why does diversity matter? And to get an answer to this, I reached out to some former interns and some students and some practicing attorneys just to get their point of view as practicing attorneys appearing in front of the courts, why it does matter. And overwhelmingly, the answer I got was that when you have people who are in positions of power, or you have people on the judiciary, you have people who are in positions of authority that look like you, that you can identify with, it makes you feel more at ease. It increases the trust and confidence that's in the system. When I, remember my old clients from the public defender's office walking into a courtroom to pick a jury, and they're faced with a jury pool and attorneys and judges who look nothing like them, there was a sense of distrust. There was a little bit more distrust in the system. There was a little bit more strain and just not really understanding, not really thinking that the people who are in front of you understand your life experiences as well. And so, one of the best sentences I got was, the best way to serve your client base, which is our constituents and those in the system, is to have more people who look like them in positions in the judiciary. Another reason why I think diversity and inclusion are important in the judiciary is that we all have a different pool of knowledge. And I think that being able to pool that knowledge based on our different backgrounds really creates a more intellectually rich, group of information, an intellectually rich experience that we can draw jurisprudence, we can draw experiences, we can draw law from. I might look at a set of facts and see it differently from a colleague of mine based on experiences that I've had with clients, experiences that I've had in my personal life. And I think that being able to share those different points of view amongst our court and our judiciary is beneficial to everybody. Our court sits in panels of 30. And so when you're able to share your experiences and your background with the other members of your panel, I think it helps the law overall become more reflective of those we serve. As far as getting more women to run for office, I do think that a lot of us who ran for office were inspired by women who we admired and women who were elected. I know for me, when I was a practicing attorney and I was in litigation and I didn't really know how I was going to balance having a child and being a single mom with trying cases and being in a courtroom, I went and found a woman who I so admired. I just saw her in court one day, and she was, you know, so put together, and I had heard that she was a wonderful mom and an amazing attorney, and I kind of talked to her about how best to balance those things in my life. And when I decided to run for office, there were definitely women I sought out who were mothers and who had school-age children. And there were many candidates who I ran with who have become some of my dearest friends who had school-age children, and we all were able to share our experiences and, you know, vent to each other and share potential ways for us to solve scheduling issues, you know, offer to watch each other's children if we had a campaign event we had to go to. And I think it really built a strong sisterhood and a strong bond amongst all of us. I think that the more women who run for office, hopefully will inspire more women to run for office. And I think that the more women who run for office and the more talent we can get and the more representation we can get does nothing but increase, you know, the public's confidence in our system, and it increases the quality of the work that we're doing. I, again, was just incredibly humbled and so amazed at all of the, you know, particularly the younger generation who I met, the college-aged and the law students, females who just really sought out all of the female candidates and were so impressed with everybody running, and, you know, they were inspired to do things and inspired to make change. And ultimately, what we'd all like to do is inspire the next generation coming up behind us to keep changing everything for the better. You know, I was talking to a friend of mine, my son and most of his friends, majority of the judges they now know are women. And a lot of the judges they know are minority women. And I think that's incredible difference from when I first practiced and when I was in law school. And I think that showing the younger generation that, you know, even just one of us can make that kind of a change and inspire other people to take different paths in life, maybe that they hadn't thought of. That's really why I think a lot of us wanted to run. You know, we love the law. We love kind of shaping the law. We love looking at the law and studying the law. But also we want to inspire the generations coming behind us to keep fighting for what they believe. We want the generations behind us to know that their voices have meaning and their voices have power. And no matter what gender you are or what race you are or really how you identify, if you have a means and a way to express your voice and your point of view, you know, there's no limit to how much we can change. And so with that, I mean, that's kind of a brief overview of my experience campaigning, my experience on the bench. It has been amazing for me to be on a court with a majority women, with a woman Chief Justice, and, you know, just to see all these brilliant, strong women in power who are, we may not always agree ideologically, but, you know, at the end of the day, we're all colleagues and we all respect each other and we all work with each other, and I'm incredibly lucky to have them. So at this point, I don't know, are we opening up for questions or?
Yes, we are. Thank you. Wow, what an amazing, impassioned, and empowered panel. Absolutely loved each of your presentations, and thank you so very much for your thought-provoking comments and expertise. Thank you very much. We do have some time for questions, and I will open it to all of you. So feel free to jump in if you want to answer them. And the first question I have is, what advice do you have for women in law firms, particularly on concrete actions to take to promote inclusion of more women in law and government?
Professor, I think you should start.
All right, I'll take it. So the first thing I would say, I think the question said, what can women do? And my first response to that is I'm interested in structural change that doesn't require women to have to do anything more. It's not that we can't be inspired by Lean In or other advice like that, but one of the frustrations that I have experienced personally in my own professional trajectory, and one of the frustrations I have when I'm mentoring my students, is this idea that women and minority women in particular have to, if we would just do more, then it would open up the doors for all of us to ascend into positions of leadership and power. This is sort of the current version of what we used to hear was, well, women are just entering the profession, and as they move along, you know, as more and more women enter, that was sort of the mantra of the 70s. And now we hear, well, if women would just, if they would just accommodate or just adjust. And so I think there are things that women can do, absolutely. One of the most important is to take that lesson from Judge Klein, to be champions of each other, both in terms of our qualifications, but also reminding our colleagues that we experience different hurdles and challenges and burdens, and that doesn't mean that we aren't qualified or that we won't do the job as well or better, but we just might need a different meeting time or a different location or a different adjustment. But I want to push back a little bit on the idea that women need to be doing more, because I think at this point what we really need to see are structural changes in professional life that level the playing field and allow all of us to showcase our skills and our talents and our attributes. The one other thing I will say, though, for women is I think in addition to championing each other, also being willing to share our stories. So sometimes I think there's a tendency, and I know this is also true for myself in moving through my professional life, that I would be reluctant to mention that I was juggling 2 toddlers at home, for example. Now they're 2 teenagers. Now I have no problem mentioning that. I'm sharing it to all of you and the 220 some odd people who are joining us today. And that was often a tension for me. My mentors had encouraged me to set aside anything about me that made me unusual outside of the male heterosexual norm. And I think that that's a disservice to all of us as women. We need to reflect not just diversity because we're women in contrast to men, but also the diversity of different lives that we lead, and the things that we do in addition to our professional life. Those should be viewed as assets, because I think they are what make us better at the jobs we do, and something that we shouldn't shy away from sharing. So I guess championing each other, but also championing ourselves.
I don't mean to jump in here, but I can stress that enough, the championing of other women. The group of women that I ran with, like, they are some of my very best friends now. They have been with me through every life experience, you know, life's ups and downs, not just campaigning, but they were always there to remind me when I'm like, I can't do it. They're like, yes, you can and you will. And the other thing that I did want to say about that is that my son, bless him, sweet boy that he is, was my right-hand man in campaigning. I dragged him everywhere. I didn't have a choice. You know, I'd pick him up, he'd have practice, he'd have lacrosse practice, and then I'm like, you need to change into a suitable shirt because we have a campaign event. I just dragged him around with me everywhere, and he got to see a lot of interesting things. Mm-hmm. And I do think that some organizations that I went to were a little bit surprised that I was never anywhere without my son, but I'm glad that he got that experience. I cannot stress that enough, the championing of each other. They're my family. They're my friends that have become my family for life.
That's just awe-inspiring on both counts. I really appreciate your responses. Here's a question. Can you compare the ratification success of the 19th Amendment with the failure of the ERA to be ratified?
I'll take a stab at that. The ERA, the Equal Rights Act, I won't go into too much history of that particular amendment, but it essentially is equal protection for women. You know, we have an equal protection amendment, the 14th Amendment, on the basis of race. And so the ERA, I believe it was in the 1970s, finally passed both the House and Senate, but it did not pass the ratification process, which obviously is required for an amendment to be part of the Constitution. I think the reason why it was not ratified is because the ERA is a little bit more complicated than the 19th Amendment. The 19th Amendment is straightforward: give women the right to vote. The ERA, particularly during the ratification process, a lot of women who were not in the workforce were really concerned with how it would affect their lives. And to be honest with you, I think some women did not want to have the same responsibilities as a man. I know that there was some concern that women would be subjected to the draft. If I'm supposed to be treated equally like a man, that would be something that I'm subjected to. So I think that the reason why the ERA was not ratified in the 1970s and still hasn't been is because it's a little bit more complex than the 19th Amendment. Again, the 19th Amendment, very straightforward: give women the right to vote, which they should have had, you know, years and years before. And the ERA is a little bit more complicated, and it triggers additional issues that I don't think people were ready to, well, the states were ready to quite swallow.
Do you see the ratification of the ERA in the future?
I could see it passing Congress again, but I'm not sure that all the state that it would pass the ratification process, because now it's 38 states as opposed to 36 states.
Mm-hmm.
And the ratification process in the 1970s, I think it was about 2 years, and they just could not get 38 states on board. Again, it's a lot to unpackage because the phrasing of the ERA is to treat women equally to men. And what does that mean? And, you know, it's a lot more complicated than the 19th Amendment, which deals with just giving women the right to vote.
Mm-hmm.
And I'll just add a little footnote here. So as a technical matter, Virginia became the last state that needed to ratify, but of course that just happened a couple of years ago. And so we constitutional law scholars have lots of interesting questions and debates now about, well, is that sufficient? You know, maybe so, maybe not. This current administration takes the position that it's not. So I guess wait and see if Virginia's final vote on the ratification process will ever be interpreted. I imagine it will have to be something that would be litigated in the courts. But I think the last time I looked into this, even the sort of delivery and finalization of the ratification, although the vote happened at the state, it has not been sufficiently recognized at the federal level. So there's a lot of complications there to it. Some would say that we don't need it, but I'm very mindful of the fact that there are so many rights and privileges that we enjoy now that we enjoy because they were decisions of the Supreme Court. And the Supreme Court can change, and those decisions can be changed. And so I think that it would be intriguing and important to see a new founded effort securing the ERA.
And let me just add, the professor makes a good point. I know a lot of kind of pushback against the ERA, at least at this point, is that do we really need it? Because, you know, we have the Civil Rights Act of 1964, women have the right to vote. So do we actually really need that amendment?
Sort of a follow-up to that is, do you think we'll ever see 50-50 representation in Congress and the rest of government? And what effect will this have for ordinary people?
Well,
it's possible to, sorry, you go ahead.
I was just going to say, I think it's going to depend on voter turnout.
Yeah, I mean, I think so. Nevada became the first state to have more women than men in the last election in their legislature. So I think it's certainly, certainly possible. I think it's feasible. I think it can happen, especially at the state level, where we see state and local courts that are sometimes more women than men. But in terms of what does it mean for the future, I just want to really emphasize, it's something that I often talk about, but was sort of trying to slice and dice and talking about my research for the shortlisted book, what parts of it to bring to you all today. But there are a couple of chapters that grapple with these questions, and Justice Borleo mentioned them, and I want to just sort of emphasize, like if I had a yellow highlighter on the words she just shared with you all right now, I'd be like highlighting it and underlining it, just how important the equal representation of women in these roles is. And it goes both to being able to envision oneself in professional life, seeing a role model that looks like you. Madeleine Albright, one of my favorite quotes from her, she was asked if she, as a little girl, dreamed of being Secretary of State. And she said, well, no, because I'd never seen a Secretary of State in a skirt. It's very hard to envision that you can take on a role if you don't see someone who is similar to you holding it. And so the diversity of the federal judiciary and all leadership roles is important for that. But it also matters because it matters in terms of, well, with respect to the Supreme Court, which is a court of discretionary review, it potentially matters with respect to the cases that the court will decide to hear. And it can also impact the outcomes of those cases, and not just at the US Supreme Court. And it's not just not to say that a man and a woman will necessarily decide a case differently. It's also not to say that a man won't decide a case that will, advance a feminist agenda and a woman won't. Like the whole point to me is that men have represented a whole range of perspective and viewpoints, and had that play out in our common law traditions, in our legal decisions that are made. And women should be equally represented in that conversation and that tapestry of viewpoints and perspectives. And we don't have to look any further than the members of the Supreme Court who have talked about the difference their presence has made. One of my favorite stories about Ruth Bader Ginsburg is talking about how she had to describe to her male colleagues in a case that involved the strip search of a teenage girl, why that would be an especially vulnerable and sensitive time to have something like that occur. And she talked about those deliberations, and does that make a difference in how the case was decided? Potentially, yes. And that's yet another reason why I think it matters so much for the future to see women represented in the numbers that they're entering the profession. And then honestly, we deserve it. Why wouldn't we want women to be represented in positions of leadership in the same numbers that they are going out and obtaining the education and obtaining the early experience? It's a huge talent pool that we don't give ourselves the opportunity of benefiting from if we don't allow women to then move into positions of leadership and power in equal numbers.
Yeah, I think that, piggybacking off of that, there's, for my court, there's 9 judges on our court. We only needed one point of view. We don't need 8 of the 9. So I think that having different points of view and different backgrounds makes our court a richer and better, pool of information. And I would just like to say, if there are any women who are watching, or, women, and you have children and you have questions about how to run for office, feel free to reach out to us. I mean, all of us who ran, we did this also by piggybacking on other people's experiences. I mean, I cannot even tell you how many, I'm a huge introvert, which is why I'm an appellate person, right? And I cannot tell you how many people I cold called and was like, I'm thinking of running for office. I need some advice. How would you have handled this situation? Or, I really admire the way you did this. Can you talk me through some ideas? So, feel free to reach out. I'm on the court website, and, my colleagues and I are always happy to talk to people who are interested in running for office and just kind of talking to them more about the process.
Thanks. That really underscores the benefits of having diversity, whether it's gender diversity, ethnic diversity, or racial diversity represented. I appreciate that. I have one question that is kind of broad. It is open to all of you. How have women changed the practice of law?
We're silent because it's so profound.
I'm concerned a little bit about the delay also. I didn't want to talk over anyone.
Oh, well, so I'll just say briefly, I think having women in the role of lawyers and judges is a huge access to justice issue. And it goes to who our clients feel are accessible to them. And so there are many ways having women present in the practice of law have changed the practice, not in the sense that, you know, women will try a case differently than a man, or that, you know, there's a special, you know, trick that, you know, women can apply, not in that way, but in terms of access to justice, in feeling comfortable seeking out legal counsel and legal advice from someone, again, who is similar to you. I think that's a profound way. And then not to make light of it, but women changed the practice of law because by entering into professional life, the professional world had to accommodate women. And that has profound implications, not just in the halls of law firms and the halls of courthouses, but in all areas of public life, having to open up the doors to women. And the last observation I'll make about this, because I know the others will have important things to add. Again, the women in my shortlisted study, in many ways, couldn't be more different. But one thing they all had in common is that they wanted to have a meaningful professional life. They had these minds that they just felt so challenged with, and they wanted to put them to use, both for themselves to feel that satisfaction of work and professional life, but also to make the world a better place. And most of them were counseled to move into traditionally female roles by their fathers or mentors. And not that there's anything wrong with taking on more traditionally female professional occupations. At the time for these women, it was teaching, which we need great teachers. I am a teacher myself, so not to knock that at all. But by obtaining a law degree, they not only opened up doors that were literally closed to them as women, but they opened up the professional world to women generally. And so I think that's a very profound way that women practicing law makes a difference.
And I agree with all of that. And I'll just echo by saying we add things to the practice of law. We're smart, intelligent, and then we also have obviously a different experience than our male counterparts. And so I think that's important in, you know, the practice of law, the way to view a case, maybe a way to couch a case to a panel of appellate judges, to a jury. And I think it's also important what women contribute to the practice of law is that we help other non-lawyers who are women who, you know, think, well, maybe I'm not smart enough, or maybe that's just you know, a practice or an industry for men. And I think the more women who are lawyers who practice, we encourage other women who kind of second guess themselves or second guess going to law school. They look at us and they, you know, think, okay, well, I can do this. Or maybe they never saw themselves as a trial lawyer or in the courtroom. You know, maybe my skills are limited to other non-lawyer things. And so I think it's very important for there to be more women in lawyer roles in a variety of different ways, judges, lawyers, corporate lawyers, because it does help the next generation see themselves in those roles.
That's great. I think we have time for one more question, and it is, are we due for an update to our voting rights legislation to better respond to public health pandemics and access to the polls?
That's a loaded question. How much time do we have?
Take all the time you need.
I'll ask my fellow panel members if someone wants to take a stab at that.
Well, I would say that improving our voting rights laws to expand access to the polls, of course, would be a wonderful thing. And there's all sorts of issues that we can talk about, from gerrymandering to locations of polling places to, you know, whether or not a state is going to allow mailing or not, and beyond. Unfortunately, changing those laws takes time that right now we don't have. And that puts me back at saying, like, yes, there's no reason why we shouldn't be focused on that and we shouldn't be thinking about that. But at the same time, also trying to consider the small but really profound things we can do right now in real time, given the parameters and the limitations of what we have to deal with to maximize the right to vote that we've secured, even under the conditions that it is still, for many people, limited. And it may mean a very long day in uncomfortable conditions, you know, our masks with our hand sanitizer and wearing comfy shoes, standing in lines at our polling places. It may mean having to be much more strategic about securing our ballots and getting them submitted either early or absentee. And so I think we need both. And it also, I think, means reaching out, especially at a time where we are all reluctant to reach out in many ways, because we've been told in this pandemic that we can't meet in person, which is what we were all supposed to be doing together at this wonderful event. But how can we take the appropriate precautions and help facilitate the access to the polls for a neighbor or a friend or even just an acquaintance, so that they can also exercise their right to vote?
And I'll just add, I mean, it's a complicated issue, obviously, this year because of the pandemic. But even in other non-pandemic years, we've had issues with voter suppression and not really engaging in efforts, I think, that's necessary to make sure that we broaden the electorate as opposed to suppressing it. And so, I would hope that all elected officials, all of, the voters would encourage people to vote early, and exercise that vote. And that's just not for, women, that's for all people, for young people, for men, for older people. This is a democracy. It's our country. It's a government for the people, by the people. And it's, the vote is that one fundamental right that does set us apart from so many other countries. And so, again, I would hope that people would just engage in efforts to expand the electorate and make sure people have the opportunity to exercise that right. Because it's not just having it, but it's exercising it, not in just pandemic years, but in non-pandemic years as well.
I don't really have much to add to that. I mean, I agree with all that, but my thing has always been, my brother is 25, and my thing to him has always been, if you're not voting, then you have no right to complain. Right. If you want to complain about what's going on, then you need to go vote. That's your voice. That's your voice, and you need to use it.
Well, on that note, I will close by saying again, thank you all for this amazing panel and this amazing discussion. I can't thank you enough, and it is just awe-inspiring to listen to all of you. So thank you very much. And I'd also like to thank all of our attendees. And to advise everyone that if they'd like to learn more about the history of the 19th Amendment and the history of voting rights for women in Harris County and Texas specifically, that you are invited to visit the Law Library's 19th Amendment website to find more resources and reading materials there for you. We'll send the information about how to access the website in an email that everyone will receive shortly. And if you're a Texas attorney and you'd like to report your CLE credit for today's program, the same email will contain the course number that you can report through the State Bar of Texas website. And if we're able to help you report your credit, please don't hesitate to send us an email, and we'll help you figure out that that path. And again, I'd like to thank the Office of Vince Ryan, Harris County Attorney, for sponsoring CLE credit for today's program. And finally, in the spirit of today's program, and because the Harris County Law Library is a designated voter registry agency, we'd like to encourage all eligible voters to register to vote. You can find resources and information about voter registration at www.vote411.org. And that's a website that is maintained by the League of Women Voters, our community partner for today's program. And the address is also included in the chat box for everyone in attendance. So please visit that website. And again, thank you for helping us celebrate the centennial of the 19th Amendment and honor the brave women who persisted and won the right to vote. Stay well, everyone, and please remember to vote. Thank you.
Texas CLE credit is provided by the Harris County Attorney's Office. The 19th Amendment Centennial Symposium from the Harris County Law Library is accredited for 2 hours CLE and 1 hour ethics by the State Bar of Texas from October 22, 2020 through September 22, 2021. To report your credit, please visit texasbar.com and enter the following course number on your My Bar page. CLE course number 174100892. If you need additional information about CLE accreditation for this recording, please contact the Harris County Law Library by email at lawlibrary@cao.hctx.net.